Welcome to the Rush, where America moves fast.
For years, many green card holders have lived their daily lives assuming that once the card is approved, they're safe, that their rights are secure, and the rules never change. But the reality in late 2025 is very different. Across the country, thousands of lawful permanent residents are suddenly finding themselves questioned, stopped at the border, delayed at the airport, and in some cases even facing the risk of losing their green card, not because they committed serious violations, but because of small rules they never knew existed. And with the Trump administration enforcing long-ignored regulations more aggressively, even long-time green card holders are feeling the pressure. In this video, we'll walk through the most common everyday rules that green card holders are unknowingly breaking, why enforcement has increased in the last 60 days, and what you should do to protect your permanent resident status moving forward. If you are liking this video, please hit the bell button, subscribe, and like it so that you may get updates straight to your smartphone. Now let's get into the video. Across the immigration system, from USCIS to CBP and even the NVC, there has been a clear internal shift. Agencies have begun enforcing older rules that were barely noticed for decades. The most surprising one involves something simple: carrying your physical green card. A rule that has existed for generations, INA 264E, requires every green card holder 18 or older to carry the physical card at all times. For most people, this rule sounded outdated, almost unnecessary. For years, it was rarely enforced. But in the last 2 months, enforcement has increased dramatically. People are being questioned at routine traffic stops. Minor violations are leading to information sharing with ICE, and individuals who have been permanent residents for 20 or 30 years are suddenly being warned or fined simply for not having the card physically with them. Officers now have the authority to issue penalties, including fines or even short-term detention, based solely on the absence of the physical card. While most people will only face warnings, the Trump administration has made it clear that stricter consequences are allowed, and in some situations, they are being used. For many green card holders, this comes as a shock, especially those who believe digital copies or photos were enough. In 2025, they are not. A second major issue involves time spent outside the United States. Many green card holders still believe that as long as they return within 1 year, their status is safe. But that interpretation has quietly changed. Agencies have started treating any extended stay beyond 180 days as a red flag. This doesn't automatically mean a green card is abandoned, but it does mean the person will likely be questioned, evaluated, and sometimes even warned when re-entering. And beginning late December 2025, CBP is implementing new biometric exit procedures, meaning every departure and every return will be recorded with photographs and facial scans. This will give officers complete clarity on how long someone has been abroad. If a green card holder has been out for more than 6 months, officers may ask for proof that the person still lives in the United States. This can include leases, utility bills, bank records, tax filings, or employer letters. Some permanent residents returning after long trips are already reporting extended secondary inspections and temporary holds while officers review their cases. And if someone has been out more than 180 days and cannot show strong ties to the U.S., they could be found to have abandoned their status. This is why re-entry permits are becoming more important than ever before. The third rule many green card holders don't realize is mandatory: filing U.S. taxes every single year, even if they earned no income. Because USCIS and the IRS now share more data than ever, tax compliance has become a silent but critical part of maintaining permanent resident status. Officers reviewing adjustment applications, naturalization filings, or re-entry patterns have been increasingly relying on tax records to determine whether someone truly maintains U.S. residency. Not filing taxes, even with zero income, sends a signal that the person may not be living in the U.S. consistently. This can lead to questioning at the border, delays in future immigration benefits, and in rare cases, challenges to the person's PR status during a naturalization interview. With the Trump administration expanding enforcement tools, immigration officers now have access to shared databases that connect IRS records, travel history, DMV data, and immigration filings. This interconnected system means that missing tax filings can trigger questions at airports and land borders. For green card holders, filing annually, even with zero income, is no longer optional. Another rule that has quietly become more important is updating your address with USCIS within 10 days of moving. While this has always been required, it was rarely enforced. But officers are now using missed address updates as grounds for questioning when people fail to receive important notices. If USCIS mails anything to the old address and it gets returned, the responsibility falls entirely on the permanent resident. Officers have been reminding applicants that failing to update their address can affect future applications, delay naturalization, or trigger confusion when law enforcement attempts to verify identity. The AR-11 form is simple to file online, but many green card holders forget. And in 2025, forgetting has consequences. The fifth issue involves criminal history. Many green card holders mistakenly believe that old misdemeanors or DUIs, especially from 10, 20, or even 30 years ago, no longer matter. But recently, people with extremely old DUI convictions have been stopped during international travel, questioned, and in some cases temporarily detained for review. With enforcement tightening, CBP officers at ports of entry, especially major airports, have been instructed to take a closer look at older criminal records. If someone with a past DUI or misdemeanor travels abroad, they may face unexpected scrutiny upon returning. The enforcement isn't automatic, but it's real. For this reason, many immigration lawyers are warning green card holders with older convictions to avoid international travel until more clarity is available. What ties all of these issues together is a new level of enforcement intensity that caught many families off guard. USCIS, CBP, and ICE are operating with updated internal guidelines. Some of these changes are part of the Trump administration's broader immigration strategy, while others are the result of long-delayed digital upgrades that give officers more information than ever. What was once overlooked is now being tracked closely, from days spent abroad to tax filings, address updates, and past criminal history. For green card holders, these rules are not meant to create fear, but awareness. A permanent resident has rights and protections, but the status also requires responsibility. In today's environment, the safest path is simple. Carry your card, file your taxes, track your travel, update your address, and know your history before traveling. If you follow these steps, you'll protect yourself from unnecessary trouble and ensure your immigration journey continues smoothly, especially if you plan to apply for U.S. citizenship in the future. That's all we have for this bulletin. The U.S. Immigration News Channel provides all necessary visa information and procedures for your U.S. immigration journey. It is important to understand the United States immigration processing steps, visa application requirements, processing times, forms, fees, and more. We will continue to provide all information about U.S. visitor visas, such as B1 and B2, work visas such as L1A, L1B, and H1B, student visas, green cards, immigrant visas, EB1, EB2, EB3, EB4, and EB5, and family immigrant visas.
First, subscribe, like, share, that's free and go!